Good afternoon, my fellow emoluments, or whatever time of day it is for you. Welcome to another training session of loss prevention. I've put this video together as sort of an advisement piece based on, different pieces of information that have come across my desk, especially as of late. And it's information I believe you need to know. So, going to dig right into presenting some of these emoluments violations and where liberty interest, which is an interest protected by the due process clauses of state and federal constitutions, play a role. As I'm sure many of you are hearing from your constituency, much work submitted by either myself or my office. So in order for you to process that properly, you need to know what went into it. So here's an example of one of those lawful principles where your constituent is going to challenge some person in agency, right? Because we already are aware of the implications of the foreign emoluments clause, which hopefully will clarify as we go, and why these are emoluments violations and punishable under Title 18, subsection 643, for mismanagement of government funds. So anybody who's told you that I'm here to beat you over the head about taxation is incorrect. I don't mind paying taxes. But if we're going to spend, if I'm going to pay $1,000 a year for roads, for example, all $1,000 of it better go to the roads and not into some other bureaucrat's pocket. So let's get into Brady, because Brady is a very contentious source, especially right now. In cases subsequent to Brady, the court has stated that a failure by the government to disclose material exculpatory information in its possession is a constitutional violation only when a reasonable probability exists that, absent the failure to disclose, the result of the trial or conviction would have been different. So that is a place from which to proceed, but know and understand, without the information being presented in the context, there's no way to be 100% sure that it would have been different. So in essence, I understand the third pillar's plight of trying to staple Jello to the wall, especially with these foreign emoluments weaseling their way in here. Now, my place in the second pillar, which we'll get to my oath of office in a minute, reason that you're hearing this information goes back to the original Continental Congress and the reasons why we as merchants incorporate into the body politic. So that's the reason for the incorporation. Okay, so what you're hearing about how corporations have been misused, like I say, that's same bad actors doing the same bad actor crap they've done throughout history. So as if you will be surprised, I know I wasn't. So as you can see, this is an example of the year ending 2020. My lawful incorporation. This is verifiable through the Secretary of State. E-Clause LLC is a lawfully created LLC under the laws of the state of Florida, as shown by this year-end reporting. This work product does fully comply under Florida Constitution, Article 1, Sections 1 and 6, exercising political power and right to work. See pages 17, Section 7 of the Mason's Manual. So we're going to claim constitutional provision. So when the court mandated the standing of the case style as me versus this department, okay, and The only thing the court can do is mandate the standing because of these trespasses of these foreign emoluments, foreign powers, foreign pillars, Sharia law, right? So, get to that in a minute. The mandate clearly states, follow the law and the rules of the court. So, as we follow due process of law through these legislative remonstrance processes or remonstrance, however you prefer it, process in pursuit of emoluments violations. Now, why did the court mandate standing as it did? And the answer is the relationship between my wife, ex-wife, current wife, whatever you want to call it, falls under privilege, which I'm going to cover extensively in this presentation. So as we proceed, I want you to know and understand why Judge Cohen mandated the standing as he did, because the Department of Revenue or no other government agency or fiction can interfere in the familial relationship. That's privileged. Husband and wife communications relationships are privileged. So absence the proof of a crime, they cannot interfere in that relationship. That's basically the, what's already established. So starting with these three fundamental principles. First one is, again, on the clock in the second pillar. To know a thing and to be bound to know it are regarded in law as equivalent, fellow servants, right? So that's citizens on the clock. What is illegal ought not be entered under the pretext of legality, hence the interference in the familial relationship. And always in doubtful cases, that is to be done by which bona fide contract is the safest condition, except when it has been drawn up clearly contrary to the law. And that is going to be very self-evident by the time we get to this, by the time I get to the end of this presentation for you. So as you start hearing other constituents making similar claims, you're going to know and understand, from where, excuse me, they're proceeding in their exercising of their sovereign authority as outlined in Section 73 of Masons. So now, as a fellow servant, right, person in position of emolument, that's this word right here, okay? This means we're supposed to be doing something. Pursuant to the notary treaty, anything that is unlawful, fictional, untrue, right? You're going to be hearing a lot about perjury. I can't certify, I can't notarize something if I have any inclination that there is any untruth in the document. I don't know if you guys know that or not, but that's part of the limitations of the emoluments of this public office. So proceeding from the loss prevention standpoint, this is one of the reasons why my first premise is, well, let's start with all of the stuff that I already know I can't do and why I can't do it. So hopefully that kind of helps aid you in familiarizing yourself as to what, how I've conducted business throughout the course of my career and why my kid's mother finally said, okay, Uncle, Dad, tag, you're in. So, excuse me. So following the rules, right, of applicability as far as evidence is concerned. This is from the Rules of Evidence, 1101, applicability of the rules. Letter C, right? Rules on privilege apply to all stages of a case of proceeding. Doesn't matter what jurisdiction, doesn't matter what planet we're on. If there is a privilege in there, privilege is always applicable, period. So in so much as liberty interest is concerned, okay, any interference by any government actor in a familial relationships absent the clear evidence of a crime beyond reasonable doubt clear and convincing evidence is a Sharia law standard. It's not a standard recognized as either preponderance of the evidence, civil standard, or beyond reasonable doubt, which is what is necessary to deprive the right, dating all the way back to the Aziz of Clarendon, which is up through the Magna Carta and the various other charters that found their way up through the Sixth Amendment. So now that we have clarification on why those things are the way they are, okay, even so much as exceptions, things that would fall under exceptions to the rule, privilege is the exception to the exceptions. Speaking of double negatives, now you know why she wanted me to do this, because of my knowledge of mathematics and algebra, which you'll clearly understand by the time we get to the end here. So, Section E, other statutes and rules. A federal statute or rule prescribed by the Supreme Court may provide for admitting or excluding evidence independently from these rules. Now, the rules of procedure that reference the rule of evidence are Rules 101 and 502. So I'm going to cite the criminal rules of evidence, or I'm sorry, the criminal rules of procedure, in that what it would take to deprive the right, deprive the liberty interest. So that's the reason for citing criminal rules as opposed to civil rules. We know none of this is civil. Every bit of this is criminal. Treason is treason. So it is what it is. So in so much as a policy, how I would apply the policy to further limit, and obviously pay due respect to what's already established, pursuant to the addition of Rule 1101 in the 2020 Rules of Evidence. So, as I advise my employees or clients or whatever, I need to, full disclosure, be further advised to extended limitations on the admission of evidence as previously established in the exclusionary rule, the fruit of the poisonous tree doctrine. Those are two very prominent ones you're going to get to know. The falsus in uno doctrine, which is false in one thing, false in everything, more Latin. The clean hands doctrine, you're going to hear multiple different explanations of this. I recommend going right to the dictionary. Always proceed from the dictionary. Just my experience talking. Right of discovery, as it's covered under Brady versus Maryland. Okay? Because we're talking about these actors they want to deprive, interfere in the familial relationship. So they wrote, basically what happened is we're reviewing these contracts, okay, that we know are not lawful. So in so much as dismissal, and why dismissal and expungement, okay, it's one thing to dismiss it, it's something else to expunge it, because you have to make the person whole again. So dismissible is grantable as outlined in Rule 12 of both civil and criminal procedures. Now, is this where I said I was going to refer to the criminal procedure under Rule 12b3b5 for failure to state an offense. Now, in 2014, this particular case, Peterson versus Peterson, clearly established why statutes, codes, rules, and etc. are not law. So if these people are going to charge somebody under a statute, a person under the statute who's out in the sovereign, off the clock, they don't have standing to do that, period. So, for example, if one of the constituency, person of myself or officer of my company, under Article 6, under witnesses, ask this particular question, or competency to testify in general. So in accordance with Rule 601, every person is competent to be a witness unless these rules provide otherwise. But in civil case, but in a civil case, state law governs the witness's competency regarding a claim or defense for which state law supplies the rule of decision. So now this is where we start to get this is where things start to get a little crazy. Can the witness define what emolument from which he or she is proceeding? Under Rule 12B3C, right, suppression of evidence, right, that's the Emoluments Violations under Brady. So that's why I said this starts to get a little crazy, because when you hear emolument, you're thinking Article 1, Section 6, Clause 2, which has a definition. Article 1, Section 9, Clause 8 does not. These are those foreign emoluments, foreign powers. So I'm going to get into that here real quick. Jurisdiction of this office. Myself and my officers particular stems from 28 U.S. Code subsection 1443. Now, insomuch as proving negatives is concerned, what we wanted to do was protect the Sixth Amendment, going back to the Aziz of Clarendon as stated, right, where the defendant bears burden of establishing his or her right to remove under 1443. There's the charter school versus Charter School of Pine Grove Incorporated. That's the case cited by the federal judge in this case. So here's the criteria that establish this jurisdiction. Most of my clientele can actually meet both, because it's either one or the other is what is necessary. But most of my clientele, as a matter of fact, I think pretty much every one of them by now can probably hit both. So that's the reason, okay, when we talk about, to know a thing and to be bound to know it or regarded in law as equivalent. Well, what am I bound to know? The same thing you're bound to know, right? Letter of the law, the diction, that's established by the constitutions, right? So insomuch as juris being the color of law, right? That's the signification of the word jurisdiction. So when you combine juris and diction, now you've got color of law, right, to work with the letter of the law. This is a 1, 2, 3 process. First one is stating your claim in the legislature to decide what jurisdiction you're going to even, you would even proceed from there, right? What was the right trespassed, et cetera, et cetera, et cetera. Executive has served a copy of that for any investigations. And getting into the third pillar, okay, for example, a lot of these cases would end up in what's called a court of errors. I haven't seen a court of errors in my state. So again, that mechanism, though it does exist in law, is not available to provide relief or remedy for this problem. Hence the reason that you're going to start having to end up ultimately expunging these cases. And of course, removing these fake privileges, fourth pillar, fifth pillar, yada, yada, yada. So insomuch as jurisdiction is concerned, right, these jurisdiction is stemming from points of authority or those pillars of law. As stated, we have 3. So in the private sector, right, when in my work of the corporations, the incorporation, right, that's the market, margin, and capital. That's the relationship to advantage, profit, and gain, which is fundamentally why businessmen make better politicians than bar members, because we are already programmed that the beneficiaries of what we do every day is the people, fundamentally, principally. So there's the reason why you're going to start seeing a lot of businessmen probably are going to be getting elected, hence President Trump. So insomuch as the law is concerned, when speaking of President Trump, Executive Order 13781, when he took office, and by then I was pretty deep into this project, right? And yes, I'm sure you're probably laughing. I love Bugs Bunny too, so get used to it. The Article 1, Section 9, Clause 8, there's the law with no definition. And of course, the subsequent 13th Amendment, referencing specifically foreign powers, foreign pillars of law. And every time we have to come up with this question, we always end up right where we were in 1871, Civil War. This is the inherent nature of the bar. This is why you're going to hear the joke, are you going after the bar, bro? Well, now you know why. That's why I said this is the same actors pulling the same crap. And if you notice, the argument is always the same. We're talking about foreign actors. They're talking about slavery. Those two things just don't. It's ridiculous. So if you're looking at the 13th Amendment in the law, any law dictionary, it references the 13th Amendment as a slavery protection. Wrong. Right? There's where the wheels came off the wagon. The one that the bar members wrote after they burnt the Capitol Records building down, which later became the White House, and altered Article the 13th, which now is the third, obviously we call them amendments. There were articles in addition to. This particular amendment article was the last properly ratified article to the Constitution, been verified through congressional record by not just this office, by multiple peoples. So you're just going to have to accept that that's the law, right? It is what it is. No one's above the law. That's pretty much the short version of what the Emoluments Clause and the correct 13th Amendment establish, right? No one's above the law, period. It is what it is, right? Everybody has a job to do, right? You here, you there, you over here. That's pretty much the way hierarchies work. So, what does fraud mean with respect to this? Well, fraud, which of course, common observance, right? We're going to get into that coming from the dictionary, starting there, which is a knowing misrepresentation or knowing concealment of material fact made to induce another to act to his or her detriment, right? Fraud usually, in so much as the law dictionary recognizing it, usually in a tort. So, it does further go on to here as to clarify this sort of kind of an artifice by which another is deceived. Okay, whatever. In so much as these Sharia law and these fake agencies are concerned, these foreign corporate agencies practicing Sharia law, right? Their intention is to indoctrinate our kids into believing that Islam is the end-all be-all of human existence. Well, the First Amendment specifically states Congress shall make no law respecting an establishment of religion, hence Title IV. So, number two was a reckless misrepresentation made without justified belief in its truth to induce another person to act, right? And of course, number three is a tort arising from a knowing or reckless misrepresentation or concealment of material fact made to induce another to act to his detriment. Now, why does this matter in relationships to the third pillar? The answer is because the bar has maintained a monopoly leveraging over the court. So many of these cases would have never happened, right? Or they would have proceeded into the proper court. For example, courts of error. When was the last time you saw a court of error? I haven't seen one here in Florida in recent history. So a lot of times too, you're going to start to hear things like the word unconscionable as mentioned here, an unconscionable dealing, especially a contract. In contract law, the unfair use of power arising out of the party's relative position and resulting in an unconscionable bargain. People are forced to accept a plea or accept these quote unquote services, right? That's fraud in the inducement as far as I'm concerned. And I'm sure many of my constituency as well as yours would agree. So now that we've clarified, okay, what common observance of fraud would be, okay, so this is your constituency talking here. Let's get into how the court, the third pillar, views fraud, right? So in 1985, there was a case Bullock versus United States, okay? The court defined fraud upon the court is fraud which is directed to the judicial machinery itself and not fraud between the parties or fraudulent documents, false evidence, or perjury. The average constituent reads this and their head explodes, right? So the question becomes, what is it that the court was looking for? This to me is hey, there's more work to be done here, guys. There's something going on behind the scenes. You need to investigate this. Well, as an auditor, that's why kid's mother said, okay, Dad, go do your job. They did further clarify to say it is where the court or a member, excuse me, is corrupted or influenced, or influence is attempted, or where the judge has not performed his official function, thus where the impartial functions of the court have been directly corrupted. So a lot of your constituency are probably going to fall under the second half of that definition. Why? As I with the opening of this presentation, decusius, who is this jackwagon and what are they doing here? Show me in the Constitution where it says that emolument exists, right? So hence the complexities of the bar members refer to the foreign emoluments clause as the anti-bureaucracy clause, which is only half right. So letter of the law, Article 4, Section 4, the United States shall guarantee, right? This is not a could be, might be, whatever. This is a guarantee here, right? Every state in this union a Republican form of government. So when you start seeing contracts written with the words domestic violence in them, don't laugh too hard. Imagine what's going to, many of you husbands or wives are going to, how they're going to realize that this foreign ideology has entered them into a domestic violence contract, hence the marriage contract. I can tell you right now, my wife was not happy. So, in so much as who's unleashing the Kraken on who, again, her and I, we don't agree on much, but we both agreed that this just flat out, I'm just going to say it pissed us both off. So, you know, there's one thing that her and I we do agree on is don't think you're going to pull any shenanigans on either one of us as highly educated people and they're going to get away with it. Not going to happen. Forget about it. So this, you know, fake government that's established itself over the decades. Yeah, you know, hey, as I said, you know, do I believe there's going to be a civil war? Shit, I think we're already there. But, you know, hey, 6 and 1/2 dozen of another as far as this goes. So, in so much as how I established a science, right? The way to ultimately attack ultimate illogic and ultimate unreason is with ultimate logic and ultimate reason. Mathematics is that ultimate logic and ultimate reason, and you're going to find out why. So when I issue a writ of supervisory control under my jurisdiction, what I'm actually doing is this definition. This is a writ issued to correct an erroneous ruling made by a lower court, either when there is no right to appeal or when an appeal cannot provide adequate relief, and the ruling will result in gross injustice. This can be verified in Black's Law, 10th edition, page 1849. So, knowing and understanding that the theoretical foundations of this office's practice, which of course is going to, again, piss off the fourth pillar, and as like you. I really don't care. The difference between them and me is I work off of established science. I don't care about what their feelings are. So as you're listening to these bar members and their circular arguments with their clear and convincing standard, hence quadrant 4, right? Those emoluments of statutable plunder. Well, that's you and me, fellow servants. We got to get rid of these foreign emoluments, get them the hell out of here. So however they weaseled their way in here, right? Somewhere way before we got involved in this. My understanding is this crap happened originally when O.J. Simpson was on trial. That's about the time that Title IV was passed, Sharia law, right? So the president refers to Biden's crime bill, right? The Brady bill. So of all of the names to pick to pass a bill, why Brady? That'd be a good parliamentary inquiry just moving forward, right? So if he wasn't attacking the Brady standard, right, denial of exculpatory evidence in a criminal case to deprive the right, why name the bill Brady? I'd like to bring Joe into oversight and ask him that question myself. So, hence the joking reference, parliamentary inquiry. What emolument is that? Well, now you're getting to know and understand the complexities of the second pillar, which is us, execution of the law. So, in so much as this word and its constitutional implementation, right, and how it works in so much as establishing the judicial machinery, as talked about in the Bullock case, starting with the Declaration of Independence through Article 6 of the Articles of Confederation, Article 1, Section 9, Clause 8, and the correct 13th Amendment, is the succession of law in this nation called America. Now, the foreign actors and their agenda, I don't care. So, too bad, so sad. That's the law. I didn't write it. My wife didn't write it. And this trespass happened before the rest of us got here. So as to who the heck am I and what was my position in life before, there was life before tyranny. Imagine that. I was the corporate level parliamentarian, right? My job was to advise the board and deal with cross training. So in so much as training different departments, right? Why accounting needs to know what human resources is doing or vice versa, right? Or why accounting needs to know what's going on in shipping and receiving, why those two things are important, believe it or not. There's a lot more to that than most people even comprehend as much as the supply chain is concerned. So we'll get into positive and negative shrink another time. And so in so much as the question, right, that comes before your body with a specific reference to Brady materials as they're defined, this definition actually came from one of my law enforcement training manuals on evidence, criminal evidence. So directly from the criminal evidence book, right, here in the state of Florida, this is information favorable to the defense in possession of the prosecution, material to the defense's case that must be disclosed to the defense, the term derived from the case under Brady. So Brady versus Maryland. So now we know what emoluments violations under Brady, we know what they are. We know from what pillar, what foreign emoluments they're stemming, right? This is the reason why it's up to Congress, right, to repeal, right, reform and repeal the implementation of these foreign emoluments. So again, this is specifically one of the reasons we're dealing with this damn pandemic. So these foreign actors can come in and literally take your job right out from under you. I don't know. How do you feel about that, Congress? So I know I was plenty pissed when they pulled it on me. So, I'm just going to kind of leave it at that. So in so much as parliamentary inquiries are concerned, This is the shortest process as a way, as a means for a constituent to enter into oversight, right? It's a political question. And for example, domestic violence is a political argument. So is there a assault or battery situation? Every case is going to be different, right? So hopefully now you know what is a republic, right? Can you define it? I would certainly hope you can by now. But these are some questions you may want to proceed with as you are working and training alongside of other fellow emoluments, right? Which manuals, for example? You know, here in Florida, we use Masons and Jeffersons. Other states use Roberts and Reeds as well, depending on your municipality. My vote is if we're going to use Masons in Tallahassee, Masons should be the preferred manual in every jurisdiction. And as far as, you know, every legislative body. So I'm working on actually to become a vendor with the book's publisher so I can work with you guys for distribution across the state of Florida. So that would be one of the things that I would do, is in so much as a supply chain. So did you know the fundamental law, was altered in 1996 with Sharia law, violating the First Amendment? Before this, probably you probably didn't know. So, and that's okay. That's fine. So now that we know, we can fix it. So, is there even an assembled committee for oversight on this or that, whatever, pick of that. So if there is, great. If there's not, we need to fix that. So, you know, in so much as assembling the information, there's a lot of groups out there that have done a lot of good information. So in so much as where my status, standing, and jurisdiction are, I hope that covered. Hope this presentation helps clarify that. So, knowing and understanding my standing on the clock is the second pillar. Off the clock is, of course, back to the sovereign. So the two words sovereign, citizen, you can't marry those. You can't be on and off the clock at the same time. So sorry, Democrats, that you're not going to further deny and disparage other rights retained by the people. See the Ninth Amendment. So what is your standing? Why should Congress comply? That's a good question. So that you go to page 563, oversight of any government offices at all times, legitimate function of the legislature. It's page 563, number 10. So how much does any one of them really know about what's going on? Well, if you don't even know what an emolument is, right, as I covered and talked about under competency, you see the point. So what good can come from assembling an oversight committee if the end game is a repeal? Therein lies, that's a good question. The reason that we assemble these committees is to do just this. Cross-training current members, but we also need to train new members. And I don't care if they're actually a senator, a representative, or even just a staffer. I'm sure, you know, the old joke, good help is hard to find. Well, you know, bringing your staffers in to train with you it might actually be a good thing. So in so much of the performance of your duties, one of the rules of thumb I always followed in loss prevention was I always wanted to train my replacement, because I always knew I wasn't going to be there. I'm not going to be here forever. So in order for things to keep functioning, right, properly, I would have, you know, mentoring programs. And that's how I always handled it. So again, you know, sort of a preference thing. But getting into specific process for requests other than parliamentary inquiries is a reason for that. I put this slide in here. So section 254, there are numerous other requests that should be distinguished from parliamentary inquiries. For example, request to withdraw a motion, which of course, some of this is internal, some of it not. Request to withdraw a motion, a request to be excused from duty, or a request for some privilege. Okay. the request for privilege you're going to get is request for, hey, the privilege between my wife and I or whatever needs to be, clearly observed here. Got these jackwagons interfering. No, get out of here, right? Believe me, my wife and I can make each other mad enough. We don't need anybody else getting in between that. So these requests are usually subsidiary in nature. They arise out of certain other questions and should be decided before those questions out of which they arise. Thus, the request of a member to be excused from voting on a certain question would be in order when that question comes before the House for a vote. For example, you have a personal knowledge or a personal familiarity with whoever the constituent is, or maybe a business relationship that preexisted your involvement in Congress. So, again, knowing and understanding how fickle people are, God forbid you might make 2 cents before you did your job. Now all of a sudden, that's an emoluments violation. Hogwash. So, because our job in discharging our duties, right, that's really what it's all about. So what these bar members are asking you to pass these bills of attainder, that's the reason that people are pissed about the money trail, right? They don't care about you discharging your duties. What they care about is the bills of attainder. So such requests are not subject to amendment or other subsidiary motions, but if denied, may be followed by a motion to the same effect that may be subject to debate and subsidiary motions. So be careful before you deny, right, certain subsidiary motions, because you could find yourself in a debate situation that could have been resolved, right, in the private. So, that's why I said this is just voice of experience talking here. So, right of discovery, right? And a constitutional obligation required the prosecutor to reveal evidence favorable to the defense. That's called exculpatory evidence. So, in so much as the right of discovery is defined, this is the right afforded to the adversary in a trial to examine, inspect, and copy the evidence in the hands of the other side. Hence my constant question, where's my report? I'm entitled to that. Your constituents are also entitled to any document with their name on them, right? That's a Freedom of Information Act. So if a bar member tells you, oh, they're not privy to that, hogwash. If it's a document, it's got their name on it, it could be potentially exculpatory in some nature that you and I and the bar member and hell, even the judge may not know. That's the reason the Freedom of Information Act was created, to prevent this problem. So in the federal rules of criminal procedure, Rule 16, for discovery in criminal cases to achieve a number of different goals, right? I'm not going to go down through them, but in so much as why this information is material, okay, in deciding, number one, is this a civil matter? Is it a criminal matter? And does it fall under Article 1, Section 9, Clause 8, and require writ of supervisory control to return the property that was stolen, right, whatever that is, and ultimate expungement, make the people whole again. So because of the one-way street limitation, discovery historically has been relatively rare in criminal cases, with 3 major exceptions. Here they are. And this is why many of your constituents, as well as mine, whether they're employees or whether they're potential clients of this office, okay, they're screaming they want their information, right? And that, again, is potentially relevant under the Brady standard. And why I said, why the president keeps going after, Biden's crappy Brady bill, right, with reference to the Second Amendment. we already know what they're trying to do. They don't want us having guns so they can come in here and lock us all up and all that hogwash. Let's just quit dancing around the elephant in the room and clear the air here, shall we? Because I've got work to do, you've got work to do, and the sooner we can get back to it, the happier we're all going to be. So, number 3, I want to pay specific attention to, because the defendant's right to discover written or recorded statements of witnesses, right? That also includes persons in position of licensing. License to do a specific job. For example, somebody working in transactions like myself, some kind of medical record. How is it somebody has a medical record with constituent's name on it, but the constituent doesn't have a copy of that? I would have a problem with that. There's no other explanation than Sharia law. I don't like it any more than you do, but it is what it is. So let's see, required to be turned over in accordance with the Jenks Act, right, in federal court under the similar state statute. So when you go through and you're starting to see some of these requests coming through, these people are not only just stating their claim, they're deciding which jurisdiction, right? Are we talking, is there, court, to say court of errors would be laughable, right? Because much of this is treason. And of course, as the maxim states, treason exceeds all other crimes and punishment. So, that's why I said some of these investigations, even as Bill Barr has said, these investigations take time, right? My particular case, I found transactions related to me going all the way back overseas, specifically to Iran and China. So, again, in so much as the case argument, many of you have read the remonstrance, have seen this, this particular reference, and why I put it in this presentation was because this is probably pretty much the way you're going to start to see this coming across your desk. So there's more than sufficient law and sufficient stare decisis to conclude this agency has no standing in law to jail people for financial debt. See Article 1, Section 11 of the Florida State's Constitution, the law, right? So can I write a contract on that? No. So how are they getting away with it? Hence the foreign pillars, foreign powers crap. So any indication to the contrary would imply this court, right, has no regard for this section, which is why when you're going to hear these constituents say, and they would say correctly, well, the Florida Constitution says blah, blah, blah. And these jackwagon idiot Islamic 4th and 5th pillar actors are saying, well, the Constitution doesn't count here. Well, guess what? If the Constitution doesn't count, how are they getting paid? Does that make sense? So you can't get back from, you can't overcome the law of your creation. So you see the problem? This is the reason this is an injury by fellow servant. So that insult to injury, there is more than sufficient proof on the record to establish financial obligation for which has been claimed is in fact false, because it's all false, right? Exonerating evidence proving this has been purposefully withheld. In my particular case, keeping this 8 out of every $10 scheme going, hence the reference to Brady. So copies of that audit are available to you for clarification, right? As sort of an example, do I mind playing crash test dummy? Yes, I do. Will I do it if necessary? Yes, I will. So again, it's lesser of two evils as far as that goes. The lesser of two evils being I don't have to get screamed at every other month about why the hell these foreign emoluments are stealing the child support money that was supposed to be intended for my kids. Idiots. So again, further clarification on Brady. Okay. This was, just another revisit to the opening slide, right? Make sure we keep that fresh in your mind, because in so much as where this fell in the, in the book, right? Remember, this came from the criminal evidence book. So, or, yeah, this was in my CrimEv book. So that this was just, where that paragraph came. So it basically starts with Brady here, right? Kind of gives you the synopsis of the case and then why they said what they said. So let's see here. Yeah, the Supreme Court held, I think this was jurisprudence, that the Supreme Court held that suppression by the prosecution of evidence favorable to the accused upon request violates due process, Fourth, Fifth, Sixth Amendment, where the evidence is material either to guilt or to punishment, irrespective of good faith or bad faith on the part of the prosecution. In so concluding, the court stated, I don't know if I totally agree with this assessment, because by the time this was written and foreign emoluments had already penetrated. So I understand the Supreme Court is end up going to have to go in and, redo a lot of what's been going on in their pillar as well. That's why I said this is a common problem. So acting from the second pillar, I'm sensitive to that. I do everything I can to avoid the third pillar because of the monopoly leveraging of the bar, hence the problem. So, in so much as the second pillar, law enforcement, let's get back to that, right? We're going to enforce the law. What law? So cue the final Jeopardy question here. As the word emolument is also pertinent to the following job description, law enforcement, can someone explain to me how you can lawfully exclude it in law enforcement training materials and call any case lawful outside of maybe murder or rape or, some actual crime victim? Because 99.9% of the cases you're going to hear about, there was no victim. The constituent was the victim. So, and of course, if the constituent's the victim, Lady Justice must also be the victim. So, a couple of principles as we're going through litigating these fraudsters, because that's what they are. Every bit of this is fraud. So, standing has already been mandated, right? So thank you to the judge. Thank you to Judge Cohen for, his work in that. Brady doesn't give me orders to execute that mandate further, because there's going to be, as the Democrats are emptying the jails, I'm going to be refilling them with their foreign emoluments. So that's what that's going to amount to. In so much as fraud, well, great fault or gross negligence is the equivalent of fraud. So hence, when you start to see contributory negligence as part of the defense, right? Who was negligent and why? So where was the fault? That's the reason the case falls apart under the fruit of the poisonous tree doctrine easily, or the falsus in uno doctrine. Either one of those two. Constitutional doubt canon can be used, though it's not readily used by courts. I don't know why. I think they should use it. It's a tool in their toolbox. But hey, maybe we need to have a meeting with them and find out why they haven't been using it, right? That'd be a good request, good meeting to have with the justices of this state. Because if they got tools in their toolbox and they're not using them, there's got to be a reason for that. So, fruit of the poisonous tree doctrine is basically the rule of evidence derived from an illegal search, seizure, arrest, or interrogation is admissible because the evidence, the fruit, was tainted. Is inadmissible, my bad, because the evidence, the fruit, was tainted by the illegality of the poison tree, right? The unlawful search and seizure. So this is just basic dictionary definition. Kind of helps you understand what the fruit of the poisonous tree doctrine is and how it works, or why it works. So, concealment. This is going to be another thing. Remember, those Brady materials do fall under concealment and non-disclosure. So, in jurisprudence, the section on concealment and non-disclosure be it not even so much incomplete as much as this is, I say, problematic. If I were going to put a word to it, I would put problematic into it, because when you're talking about, concealment and non-disclosure, the read through of jurisprudence does not fall under common observance in so much as the Republic is concerned, hence the fourth pillar and how they've been getting away with this crap. So that's the reason I'm presenting it now and making it available to you, so you can see the comparisons and conundrums and where all this crap came from and why we have to clean it up. Like you guys, I'm tired of cleaning up everybody else's messes, but hey, lesser of two evils as far as I'm concerned. So we're gonna start. I want you to start sending out subpoena duces tecums, right? FOIA requests. You might get FOIA requests from a constituent. That would be a subpoena duces tecum, which is a subpoena to order to appear in court, commanding a person to bring specific documents or subjects with him or her. So a duces tecum in the context of Congress would be, hey, agency XYZ, you've got information, and if you don't bring it, I'm going to prosecute you. That's basically the short version of what that is. So in so much as between the first and the second pillar, if a constituent says they need a duces tecum subpoena for some specific record that the agency says, oh no, that's private information. Well, wrong. My tax dollars, your tax dollars are paying them. They're going to bring it forward. So that may require also a notice to produce, which is a formal written notice issued by one party to another requiring the production of a document. So knowing and understanding, to know a thing and to be bound to know it are regarded in law as equivalent, right? So, okay, this is stuff I'm bound to know. So you may start to see notices to produce. Okay. I call them notice to agent, notice to principal. But ultimately speaking, it's a note. It becomes a notice to produce, somewhat of a be advised kind of a thing. So here's some short definitions: notice to produce and duces tecum. How an original document would be defined is viewed by the court. The third pillar, if we get that far, what a certified copy is, and what a exemplified copy is. So, and where each one of those may play a role depending on which jurisdiction we're talking about. So, knowing and understanding that if you're going to grant standing in jurisdiction with somebody who doesn't completely understand the difference between how many pillars, you might want to consider granting jurisdiction to subcommittees, subquorums, okay? And they could, prepare these documents for you, right? You sit down, you tell them, look, I'm going to need you need to fill out, right? Notices to produce, duces tecum subpoenas, and send them here, okay? And then submit a report back to you as to when that work was done, right? So that's just an inspect what you expect kind of a thing. So again, this was part of my job, making sure following up on all that stuff that was done. So document custody of a public officer, there's process for that, okay? So that's Federal Rules of Evidence 1005. So you can get to this under Federal Rules of Evidence as stated there. So this is a clear-cut, easy way to obtain a copy of an original record, or even the original record, if expungement is going to be the end result anyway. So sometimes in criminal cases, prosecution must prove that the accused was convicted of a crime in another state or in another court proceeding. Well, here's a conflict by that. Supreme Court has held on multiple situations where even in rape cases, which completely blows my mind. Prior convictions cannot be used in the current case. So where did this come from? So, you know, if you're talking about something as extreme as rape, where they can't use a prior conviction, but these actors, these Sharia law, you know, foreign emoluments are saying, oh, I'm going to use that as their quote unquote clear and convincing, right, evidence standard. Well, here's what that does. Causing is the cause of the effect. What actually they're doing, right, they're whittling away at your good standing, your constituents' good standing, right? That's the Ninth Amendment violations, right? Period. You just read a general read of the Ninth Amendment, right? That's a disparagement of a right retained by the people, one of your constituents. So documents in possession of an adverse party, you know, so I said I just went through that. Lost or destroyed writings, recordings, or photographs. Most of this stuff, if they're destroying evidence, it's because they don't want to be convicted. Know it, accept it, understand it. Whether you needed me to tell you that or not, I probably don't know. You probably already knew that. So again, here's sort of a process for that, right? How to handle that, knowing that expungement and the return of the property and seizure of the fake emoluments property is going to be the end result. So clarification on what a collateral matter is, right? You'll hear collateral damage, collateral matters, you know, here you go. So collateral matter is only incidentally related to the issues at trial. When the contents of a document relate to such a matter, the original document need not be produced in court. So this is where you get into utilizing a certified copy. So we see a lot of this in transactions. So, you know, for example, you can't always get a copy of the original, or you can't always attain the original, but you've got copies in your files for whatever the reason, audit purposes, whatever. So knowing and understanding the difference between a petition and a remonstrance. Petition is what the bar members use because they have to pray that nobody catches them committing treason. Your constituency exercising their sovereign authority, hence the remonstrance, okay, that has no prayer. This is them coming in saying, here's what I want you to do, here's how I want you to do it, here's why I want you to do it. Sign here, right? All we have to do is send the documents over to the second pillar, order the investigation. 99 times out of 100, it doesn't take, you're going to get information back relatively quickly. You know, even if it's nothing more than somebody going over to an agency saying, hey, I got a request from a congressional member. I need files on blah, blah, blah. Simple. So what do we do with them when we get them? There's a process for that. It's called impeachment. Okay. So sole power of impeachment's in the House of Representatives, hence where the articles come from. Trials of this nature are to come in the Senate. So that's what, you know, now you're getting into knowing and understanding what the responsibilities of Congress are supposed to be, not what you've been doing, right? These relative foreign emoluments have been tricking you into giving away your power, basically rendering Congress impotent. Well, they're going to tell you, well, yeah, we have it now. You can't take it back. Want to bet? How much you want to bet? So you just go in and say, because that process, right, the letter of the law says, what we can giveth, we can taketh away. Pretty much the short version there. So that's the reason that much of this is going to result in repeal, right, and resolution. So thank you for your attention. And should any of you wish further clarification or oversight on any matter, you may contact me directly as follows, right? And you can at 16062 Southwest 34 Court Road here in Ocala, Florida, by phone 352-470-8460, by email eclausellc@gmail.com. And the reason I chose this particular server was because it has Dropbox and file sharing capabilities, right? I can use a different server, right? Or we can do direct mail, however you guys want to do it. I really don't care. You'll find I'm pretty flexible in all that. So knowing and understanding that what this means moving forward, right? Because you're sick of these bar members, I'm sick of these bar members and these other foreign emoluments, right? And their agenda and what it is they're actually planning on pulling. Many of you have read probably most of that by now. So knowing and understanding there's going to be life, maybe, after this quote unquote civil unrest, or just call it what it is, civil war. You know, that's why I said, or what are we doing? So, you know, if you know how to run a republic, great. If you don't, feel free to ask at any time. So on that note, I'm going to go ahead and shut this down. And as I said, I hope you guys, or girls, ladies, gentlemen, others, found this information helpful. Have a great day.